All right, good afternoon to everybody on the East Coast. Thank you for joining us for 2022 FCA Year in Review and Emerging Trends for 2023. My name is Matt Feinberg. I'm a partner in PilieroMazza's Litigation and Dispute Resolution and False Claims Act and Audits and Investigations practice teams. While you're listening to us today, if you have any questions, feel free to use the questions option in your webinar program. I have experience in a lot of different aspects of the False Claims Act, so you may have specific questions that relate to the topics that we talk about or specifics to your own business. We'd be happy to go over some of those things. I would also like to introduce my webinar partner today, Annie Hudgins. This is her first webinar with PilieroMazza, so everyone be gentle, but I'll give Annie an opportunity to introduce herself.
Thanks, Matt. Hi, everyone. My name is Annie Hudgins. I'm an associate in PilieroMazza's government contracts group, as well as the construction group. I have a particular interest with the False Claims Act, and I'm a member of the False Claims Act Audits and Investigations team here, and I'm excited for my first webinar.
All right, thanks, Annie. Appreciate you being here. Everybody, if you've sat through a webinar with me before, you've heard this. Our webinars are intended for informational purposes only. Although we are talking about legal issues, we are not providing you individual legal advice, and this webinar does not create an attorney-client relationship. We say that because your specific situation may impact the information we provide. So don't rely on the generalities and the black letter points of law that we're talking about today to apply directly to your specific matter. If you have questions about a specific matter, we encourage you to reach out to us directly. Our contact information will be on the last slide. We'd be happy to talk to you offline about the specifics of your situation and give you specific legal advice, but just don't take what we say in this webinar to be legal advice for your specific situation.
So to start off, I thought I would give you an overview of what Matt and I will be discussing today. So to start, we'll be talking about what is the False Claims Act generally, give some background, some history, and then we'll move on to key takeaways from the Department of Justice's annual report for fiscal year 2022, which was just released recently. And based on that information, what we can expect to see in fiscal year 2023. And based on all of this information, we'll give some recommendations at the end about how best you can protect your company from FCA liability. So what is the False Claims Act? It was created during the Civil War and is sometimes called the Lincoln Law. It was passed in 1863. There was rampant fraud during the Civil War on both the Union and Confederate side. Just to give some interesting examples, some companies would sell sawdust boxes that did not have guns in them. They'd sell malfunctioned guns or ill horses, or sell the same horses over and over again. And to combat this fraud, the administration enacted the False Claims Act. And it's developed and expanded over the years into what is now the primary vehicle for the government to recover money obtained through fraud. So what exactly are we talking about when we say the False Claims Act? So what exactly is a claim? It's a request for money or property, such as an invoice is the most common example. And by false, the False Claims Act means actual falsity in the claim for that's entitlement was improper, incorrect, unlawful, or unjustified. But not all false claims are violations of the False Claims Act. There's a knowledge element. There's 3 types of knowledge under the False Claims Act, which would be actual knowledge, reckless disregard, or deliberate indifference is required for a False Claims Act violation. There are both civil and criminal false claims, but we'll mostly be focusing on civil false claims today. So there's 2 ways the FCA matters can be initiated. The first is through a government-initiated matter, and the second is through a qui tam matter. So I'll start with the first. A government-initiated matter could usually arise out of an audit or investigation that could come out of an Office of Inspector General. They may start this audit or investigation through a tip, through a whistleblower hotline, and then work its way up to the Department of Justice, which may choose to pursue the FCA matter against a company. But there's also a qui tam matter, which would be a private litigant who's a whistleblower who thinks they have knowledge about a False Claims Act violation that could be going on with a company. Something important to note about qui tam whistleblower matters is that they are not always disgruntled employees. They could be anybody.
All right, so let's talk a little bit about relevant types of FCA violations. We're going to talk about these at a very high level today. We're not going to give you specific examples until we get much later in the presentation, but it can sometimes help to have an understanding about what we're really talking about when we say false claims. So like it says, False Claims Act, there could be a false claim. That is actually submitting an improper invoice or an improper request for money to the government for payment. You could also have a false record or false statement. Just because your invoice to the government or request for payment isn't technically false on its face, you could be making a false representation that accompanied an otherwise correct payment request. For instance, if you have to make express certifications as part of your government contract, or there may be implied certifications that are implied in your submission of an otherwise correct invoice, that could ultimately, if those certifications are incorrect, you could ultimately violate the False Claims Act. We have a reverse False Claims Act matter, which is actually the government has money that you claim entitlement to in its possession, and you have made a request for that money. This comes up often in CARES Act False Claims Act matters, where, for instance, you seek forgiveness of a PPP loan, and the government ultimately says that you were never entitled to the PPP loan, or you were never entitled to forgiveness. That means the request to the government to receive money back or to not pay the government a certain amount of money, such as repaying the loan, is considered a reverse false claim. There's also conspiracy. Conspiracy just generally means that two or more people were in concert. They essentially decided together or took acts in furtherance of a violation of the False Claims Act, either under the false claim, false record, false statement, or reverse false claims provisions.
So FCA penalties have two components to them. It starts with mandatory damages component, which the damages numbers below the $12,537 to $25,076 per violation is a mandatory penalty. These numbers change often. They've changed a record amount of times since 2018 because of inflation rates, which has been in the news about the need to change these numbers often. But the second component is the treble damages, which are determined in reference to the type of claim pursued, and these are triple the amount that the false claim is for. If Matt has anything he wants to add about the treble damages element.
Sure. So just to give you some examples of how those false claims damages are calculated, let's say that you have a contract where or certain types of costs are not payable, or they're unallowable. If you submit an invoice to the government, which includes those costs, technically you have submitted a false claim because you have requested payment from the government to which you're not authorized. In that case, the damages would be considered 3 times the unallowable costs ultimately paid by the government. Let's say that you submitted invoices based on an erroneous fee or margin. For instance, your contract incorporates your proposal and you put in a 4% margin on your proposal, but then ultimately you bill the government with at a 5% margin. The difference between the 4% and 5% would be your damages, and that could be tripled. And then the most significant type of damages in False Claims Act matters on the government contracting side is when a contractor isn't entitled to award of a contract because they're not eligible under a set-aside program. For instance, let's say that there's an 8A contract, either sole source or competitive award, and ultimately it is determined later that the awardee was not eligible as an 8A business at the time of award. The government could contend that the entire revenues from that contract were false and triple those revenues, which is a significant burden on a company to try and defend, because obviously you're only recovering your profit margin, but the government could be coming after triple revenues. So all of these examples of damages and how the False Claims Act work is really important to some of the data that Annie is going to be providing when we talk about the 2022 annual report. So just keep all of this in mind as you're listening to the rest of the webinar, because it gives good context.
So for the statute of limitations, before we move on to the statistics, unfortunately for people finding themselves on the other side of False Claims Act, they have a very long shelf life. They will never be longer than 10 years, but they could start from 6 years from the time the fraud was committed, or 3 years from the time the government official investigating the fraud knew or should have known about the fraud. But the annual statistics don't normally show the current state of the statute of limitations element of the False Claims Act.
Yes, that's a really good point, Annie, and I think it's an important one to know before we start talking about what the statistics said for 2022, because you're going to hear some somewhat conflicting information. When a False Claims Act matter is initiated, it's typically through an auditor investigation, as Annie said, or through a whistleblower complaint. It can take years for that complaint or investigation to get to a point where there's an actual recovery under the False Claims Act. I personally have been in cases before where it took 3 or 4 years just for the government to get to the point where they informed the company of an alleged False Claims Act violation. And so sometimes when you see the numbers, you'll see conflicting information like a record number of False Claims Act matters initiated, but a low amount of recoveries over the year. That doesn't necessarily, that information isn't necessarily in conflict, because ultimately it could be years before we see the results of a record number of False Claims Act matters initiated. And you'll see that in the next couple of slides.
So for the fiscal year 22 year in review statistics, the Department of Justice just about a month ago released their annual report on the statistics for the year prior. So all of these numbers are based on that report. So for fiscal year 22, the total monetary recoveries was only $2.2 billion, which is a lot of money, but down significantly from previous years, down 155%. From fiscal year 21's recovery of $5.6 billion. Also notably, they've only hit $2.2 billion because of the Biogen case, which accounts for $843.8 million of that entire settlement, which is a record amount for the recovery. Something else important to note about this total $2.2 billion number is that while it's the second highest number of settlements in history, this is one of the lowest dollar amounts recovered in over a decade, which, if you think about it, means that there are lower numbers per settlement if you do the math. And then something else to note is that of the $2.2 billion, $1.7 billion was based out of government-initiated claims, and $488 million was based on on key TAM matters out of the $2.2 billion recovered. However, the total matters initiated was increased from fiscal year 20, where there were only 922. This past year, there were 948, 296 of which were from government-initiated matters, and 652 were from key TAM matters, which I believe is also.
Thanks, Annie. That's a pretty significant number, because the total matters initiated is the highest since the government began disclosing its False Claims Act numbers when the amendments to the statute came out in 1986. So this is the example I gave you a couple minutes ago. this is a high number of new matters initiated. That means the government is focusing a lot on the FCA, and whistleblowers are filing a lot of lawsuits, 652 last year from whistleblowers. That's just a very significant number. It isn't necessarily translating right now into dollars and cents, but it could, and it will over the next few years as those matters progress through the investigatory process and into ultimate litigation potentially. So those are pretty relevant numbers that seem on their face in conflict, but ultimately they're not.
So some overall takeaways for what these statistics mean. The dollar amount in recoveries was low, but the number of settlements was high, as we just discussed. That those seem like they'd be conflicting, but they're not overall. If you think about it big picture, the newly initiated rate was the highest since DOJ started releasing these reports in 1987. Something else important to note is their sharp drop off in recoveries from fiscal year 21, especially considering almost half of the overall recovery from the year was from a single case, that Biogen case that we had on the previous slide. And something else that we believe is a big takeaway is you can expect additional increases in new matters initiated in fiscal year 23. So some recommendations, and Matt will get into more recommendations later on, is to take subpoenas, civil investigative demands, requests for information, any kind of inquiry from the government or an office that's related to the government very seriously, in addition to employee complaints, employee notices, anything to your company that might raise a red flag, you should take very seriously. And you should, in the meantime, increase compliance efforts and internal audit procedures to try to avoid any of this in the first place.
One important takeaway, so the government does not announce specific statistics related to procurement fraud matters and recoveries. Nevertheless, the government focuses very heavily on procurement fraud. And there were a number of large settlements in fiscal 2022. And I'm going to cheat a little bit and pick one from fiscal year 2023 as well. Keep in mind, the fiscal year ends on September 30th. So the data we get is about 4 months old when the statistics, the annual report is released. And so I'm plugging one in from December just because it was particularly relevant to some trends that are going on in the industry so far. But the fiscal year 2022 saw the highest small business fraud settlement ever. We're going to talk the specifics of that case in a little bit, but it was almost $50 million and related to a company, a large business that was essentially finding a small business to be the awardee, but then the large business would perform all of the work, essentially bypassing the requirements of the small business set-aside nature of the contract and the limitations on subcontracting. So this next one was what happened in December. The settlement was announced. It was about $14 million, and it related to violations of the Trade Agreements Act and the Price Reduction Clause. For those of you who are government contractors on the call, you're subject to statutes like the Buy America Act, the Trade Agreement Act, the Price Reduction Clause. All of these require strict compliance with certain types of regulations that impose where you can get your products, how you can get your products, and what price you can sell those products to the government at. And knowing violations of those statutes can result in pretty significant penalties. And in this case, the allegations were under the TAA and the PRC, and they ended up resolving for about $14 million. Another landmark case that came out in 2022 was the settlement of a case called Aerojet Rocketdyne, which was originally the first ever known cybersecurity False Claims Act case. It was announced several years ago in the context of a motion to dismiss. And I think maybe one of the first webinars I ever did about the False Claims Act. And now years later, they settled in fiscal year 2022 for $9 million, essentially for misrepresenting, either through what the whistleblower claimed was both a direct obligation and an implied obligation to notify the government about cybersecurity noncompliance. So those are 3 examples of how procurement fraud has occurred over the last fiscal year, but there are many dozens of ways that a False Claims Act violation can come out of procurement. It's important to pay attention to your compliance with both your contract and the federal regulations implementing it in order to avoid FCA liability. So here's the first example I gave, which is small business procurement fraud. There's a $48.5 million settlement with Trimark USA LLC. It's the largest small business contracting fraud recovery ever. Just for your edifications, every year that I've done this webinar, and I think it might be 3 or 4 in a row, I have had to say that there has been a settlement for the largest small business contracting fraud recovery ever. So each year that number is getting bigger and bigger. 48.5 million is a lot. I wonder whether that'll be possible for fiscal 23, but the government will certainly try. They will look for errors in small business compliance and awards of contracts that are beyond to contractors that aren't eligible, and they will prioritize going after small business and set aside procurement fraud. We know this both from anecdotal evidence. Obviously, PilieroMazza represents a lot of small business government contractors, but also from statements made at conferences and the Department of Justice has made publicly about their particular focus on small business size and status certifications, set aside eligibility, and large businesses that take advantage of small businesses, either in bidding or in performance of work. We've also heard from the Department of Justice that the government is focusing very heavily on the SBA's mentor protege joint venture program and joint ventures in general, because it is very easy to violate the limitations on subcontracting for joint ventures. The rules are complicated, and failure to comply and failure to keep track of the performance of work requirements on construction and non-construction contracts can lead to significant FCA liability. And there are other particular focuses for DOJ on the construction industry to the extent that they're not following construction specs, not providing construction that it complies with the representations that were incorporated into the contract. And so if you're in the construction industry, you want to make sure you're managing your P's and Q's to ensure no FCA liability. I also wanted to point out that there is a particularized movement among the Department of Justice called the Procurement Collusion Strike Force. And this has gotten a lot more publicity over the last couple of years. It was originally created in 2018 or 2019, perhaps. And this is an interagency partnership composed of prosecutors from and representatives from the FBI, the Antitrust Division of the Department of Justice, the Department of Defense, and various agency offices of Inspector General. And ultimately what they are trying to do is identify and prosecute antitrust crimes and related fraud that relate to government procurements, grants, or other public funding programs. So this is where it comes in that there's both a criminal and civil aspect. There have been efforts, a number of efforts to seek criminal liability against companies that are violating antitrust laws, but there's also a civil component to the FCA, which is being used to initiate False Claims Act matters against companies for violations of the Sherman Act, which is the antitrust statute. So your criminal penalties for an antitrust violation could be $1 million for individuals or up to $100 million for companies. Those are huge numbers for an antitrust violation. They don't really tell the whole story because rarely do those penalties get imposed for FCA violations. FCA violations are typically tied directly to the damages, as we discussed before. But to the extent the government anticipates making an antitrust claim as well, you may see lawsuits that seek damages of 100 million or more based on violations of antitrust requirements. These types of investigations focus on things like price fixing, mergers that could reduce or eliminate competition, or exclusivity agreements that impact pricing. These are all areas where, in many respects, the behavior of the companies seems perfectly acceptable. Entering into an exclusivity arrangement with the teaming partner is pretty commonplace. The question becomes whether that exclusivity agreement impacts pricing that the government ultimately pays. Is there collusion to force the government to pay more money? There are a lot of ways you can violate the Sherman Antitrust Act, but those are the main areas where the Procurement Collusion Strike Force is focusing at this point. There's also recently announced a COVID-19 fraud strike force, which is another area of particularized focus for the Department of Justice. I attended a conference last year, which included statements by the Department of Justice, and they explained that they will seek out individuals and companies that received CARES Act funds to which they were not eligible or not entitled, and that they are going to focus heavily on COVID-19 related fraud in order to penalize individuals who took advantage of the pandemic and the individuals who are affected by the pandemic. So this includes not only situations where a company or a person received a PPP loan that they weren't entitled to receive or they weren't qualified to receive, but also includes companies that sold defective products like hand sanitizers and masks that were not or provided representations to the government or to the public that their products were of a certain quality or a certain level that would protect them from the pandemic. If those statements were false, the government has indicated that it is going to go after those companies. So far, there haven't been any significant COVID-related recoveries. And when we say that, they're obviously very significant for the companies involved and very significant for small businesses. But what we're talking about is the recoveries in the many millions of dollars at this stage. But that makes sense. COVID started in 2020. CARES Act funds didn't even start being forgiven until 2021. And so with the long shelf life of FCA Matters, there's still a lot of investigation to go before we really start seeing the larger versions of PPP loan fraud, CARES Act fraud, and things like that. So some takeaways from the government's focus on COVID-19 fraud. Even though you may have already submitted all of your paperwork to receive your PPP loan, to forgive your PPP loan, maybe all of that is in your rearview mirror, you still need to maintain your documentation. You want to support eligibility, to keep the documentation that supports your eligibility for and spending of the government funds. You want to make sure that you have that documentation and you maintain it for many years to come. At the conference I spoke of last year, the government doesn't believe that it is going to be able to investigate all of the necessary PPP loan fraud and CARES Act fraud that it will discover within the time frame of the FCA statute of limitations. And so what they plan on doing is using the statute of limitations under the Financial Industry Regulation and Reform Act, it's called FREA. And that is a 10-year statute of limitations no matter what. And so what they're trying to do is give themselves a buffer to make these claims for many years into the future. And so even 4 or 5 years from now, if you have documentation related to your PPP loans, do not get rid of it. Keep it, make sure you have the ability to justify your receipt of funds for many years to come.
So Matt and I have selected a few other items from fiscal year 22 that we believe are important, including the Biogen case and what it shows for whistleblowers that we've mentioned a few times already, but want to clarify some more. We have also been following the FCA at the Supreme Court and Matt's Scollick case, impact on construction sureties. So the Biogen case that we've mentioned a couple times already, we want to emphasize because we think that it's a good reminder of how seriously whistleblowers can impact your companies under the FCA. The Biogen case is the over $800 million case that we discussed earlier and was in litigation for 10 years. The whistleblower was able to receive 29.6% of the total recovery, which for reference, the maximum is 30%. And the whistleblower will also recover attorney fees, which attorney fees for over 10 years could be $15 million, perhaps. Matt maybe has a better idea of how much that might cost. But we think that this case overall is emblematic of how incentives for whistleblowers may receive for making FCA allegations, and an important reminder for companies that whistleblowers don't always have to be a disgruntled employee with an axe to grind. It could be anybody that might have any knowledge about a potential false claim or something going on at a company that could rise to the level of a False Claims Act violation.
Right, and one thing to think about is that these whistleblowers can be your competitors. They don't really have insider information. They have assumptions they make based on contract awards or information they see in the public. And the way that FCA has been revised over the years, a competitor had a very steep hill to climb back in the 80s and 90s to make an FCA claim. Not so anymore. In many respects, competitors can make these claims based on publicly available information, and they have sometimes been able to make arguments that they should be allowed to participate in the recovery simply because they reconciled all the information and provided it to the Department of Justice. Now, there are a lot of defenses to a competitor filing a qui tam action against a company, but the main point here is there's a lot of incentive for even loyal employees who are not disgruntled to disclose information that might be negative to the company that could lead to a False Claims Act violation. In the Biogen case, he's getting $250 million, not counting his attorney's fees. His lawyers will probably take 40 to 50% of that, and that's, they've been involved in the litigation for 10 years. But even if they take 50%, the whistleblower is going to get $125 million. It's more than most of us make in a lifetime. And you get to do this by having lawyers handle a qui tam action for it. Imagine what you would do for $125 million. Now, the Biogen case is an outlier. The average qui tam case is never going to result in $250 million of liability, let alone $250 million for the whistleblower. But $1 million is a lot for most people. And a case that is 1/250th the size of the Biogen case is particularly common in False Claims Act liability. So just things to keep in mind. That's particularly important for companies when an employee comes and complains about a business practice or claims that they think that there's something wrong, you're not complying with a regulation or statute. It's really important to vet that and investigate. Even if the employee is what you would call sort of a difficult employee or a complainer, someone who raises a lot of issues that don't pan out, an employee who cried wolf, so to speak, you still want to investigate those claims. And you don't want to take retaliatory action against the individual for making those claims. You want your employees to bring that information to you so that you can fix any problems before they become significant liability.
So something else that we saw in fiscal year 22 that will certainly and is continuing into fiscal year 23 is the False Claims Act. Certain elements of it are being addressed at the Supreme Court. Matt and I are following this in our blog series on our website if you'd like more extensive coverage. But for the Polanski v. Executive Health Resources case, the Supreme Court is evaluating whether the government has the ability to dismiss a qui tam case after it's declined to intervene at a previous point, which is significant because if the Supreme Court chooses to find for Polanski, it would force the government, usually the Department of Justice, to make policy choices earlier on in cases, because whether they choose to dismiss a qui tam case or intervene could be the last decision they get to make in that case. But if the Supreme Court finds for Executive Health Resources, it may chill whistleblowers' commitment to a False Claims Act case if they know that after putting time and money into pursuing a False Claims Act violation against a company on their own and on their own dime, the government could come in way later on and dismiss the key TAM case. So the Supreme Court is assessing that, as well as the Shoot v. Super Value Inc. and determining the exact definition of what the knowledge standard is under the FCA. We don't have decisions on either of those cases yet, but the oral arguments for Polanski happened earlier, and we're expecting oral arguments for the Shoot case in April, I believe. So we'll be following that more closely and providing more extensive coverage in our blog series on the website.
Yeah, thanks for pointing that out. I'll give another shameless plug to our blog series because we go into a little more depth in the blogs than we do here on the webinar because we have more time to talk. Ultimately, what does this mean? The FCA doesn't go to the Supreme Court very often. When it does, it's usually a pretty landmark decision. The last time was for the Escobar case. For those of you who know the Escobar case or the FCA, it is perhaps the most monumental decision in the history of the FCA. The Shoot or Shut case, it could be the next big thing because it ultimately is going to make either liability much harder to prove for whistleblowers, or it is going to make defending the case a bit harder for defendants when the case involves violation of a statute or regulation, or it's going to be somewhere in between, and we don't know what's going to happen. But what we do expect is if there are defendant-friendly decisions from the Supreme Court on Polanski and SuperValue, that Congress is going to try and take some action. Senator Grassley from Iowa is a champion of the False Claims Act, and we expect him to initiate bills to curb any decision from the Supreme Court to the extent they are defendant favorable. So the False Claims Act that you know and love today may be very different a year from now. And so tune in January, February, March 2024 to hear how those impacts have turned out. And we do this every year, and I'm sure we'll talk a lot about it next year. So I wanted to talk about this one. It's a little bit of a pet project for myself. The Scollick versus Narula case came out of the federal trial court in the District of Columbia. Little disclaimer, I was previously involved in this case representing one of the defendants. I am not anymore, but this is an interesting one for the construction industry. Essentially, this is a key TAM case with a whistleblower where the government did not intervene. So the whistleblower is taking the case themselves. Alleged that a group of small businesses that are engaged in construction essentially misrepresented their status to receive certain set-aside contracts and placed what some would refer to as an unqualified individual who otherwise met the set-aside requirements at the head of a company, but that individual did no work. The main point that we're talking about Scollick and Narula is because it created a novel argument. The whistleblower alleged that the surety company that bonded out the construction project is equally liable as the companies that allegedly violated the small business and set-aside regulations, because ultimately, the surety has an obligation to pay the government in the event of a breach of the underlying construction contract. So once the construction contract has been breached, that duty attaches to the surety. And in this case, the whistleblower alleged that the surety knew or had reason to know that the company that was bonding out the project for was in violation of the relevant set-aside regulations. And so the whistleblower tried to attach the surety, which has the deepest of pockets monetarily. Ultimately, there were motions to dismiss filed several years ago. Those were denied, which was a particularly significant holding at the time. And then during fiscal 22, the defendants all filed motions for summary judgment, which is, for those who are not aware, a motion that tries to get the case dismissed before it goes to trial. In fiscal 2022, the federal judge in DC dismissed the case, entered judgment on behalf of the sureties, and found that a surety does not have a duty to investigate or be aware of small business qualification requirements and whether a bonded company is in violation. And part of that explanation by the court was that the surety doesn't do generally government contracting. They're not representing themselves as a small business. They have no need to understand the small business or set aside regulations for their own operations. And it should not be incumbent upon the surety to investigate whether every contract it bonds out is going to a contractor that is eligible for the contract. So I would imagine that most litigation against sureties is going to take a different tack because it was a very long and well-reasoned opinion, but it closed at least one door in this instance for surety liability. So if you're in the construction industry, think about the implications of what a potential misrepresentation on an invoice or a misrepresentation relating to the award of a contract could lead to. Because if your surety is getting pulled into litigation, you could lose your bonding at a later date, and that could be detrimental to the company. So just things to think about from fiscal 22 in the world of construction. And I'm sure that we're going to hear more about the Scollick Narula case once it gets all the way to potential trial. All right, so let's talk a little bit about trends going into fiscal year 23, and this piggybacks a lot off of what we've already said about what happened in fiscal 22. We're going to see a lot of antitrust related fraud matters being investigated. It's unclear whether the litigation will start in fiscal year 23, or I should say ramp up in fiscal 23, because we're still pretty early in the procurement collusion strike force history. But we expect that a lot of investigations are going to center on potential price fixing and other non-competitive aspects of government procurement. We expect CARES Act fraud to increase exponentially over the next few years, starting this year, as the investigations into fraudulent PPP loans ramp up and reach the stage where they can go into litigation. For your reference, there's a lawyer who is doing a lot of investigation of PPP loans, and that individual is filing key TAM suits in his own name. He's identified at least 3 fraudulent PPP loans that have resulted in litigation and settlement, and he's made a lot of money in doing so. We expect him to continue to be investigating PPP loans, and that the government will start with litigation soon. Construction, as I've mentioned, it's a hot button topic for the FCA every year. We expect it to continue to be so. A little tidbit that I mentioned earlier, how every year I've been saying that there's a record small business fraud matter. As I've mentioned as well, the government is going to be focusing on mentor protege and joint venture performance of work and cybersecurity, not just with NIST requirements that may be implied or required of your company, but we've got CMMC in the next few years as well. We expect cybersecurity requirements to be a significant focus of FCA Matters moving forward. So let's talk a little bit about protecting yourself from FCA liability based on all of the doom and gloom stories that we've given so far. It is critical that you are compliant with regulatory obligations and the provisions of your contracts. You need to know what the law that applies to your contracts is and the specifics of what your contracts require. For instance, one thing that's come up over the years, you may have a contract requirement that says all subcontractors must be paid prior to submission of an invoice. It isn't a common clause, but it does frequently exist in certain types of contracts. If that exists and you haven't paid your subcontractor, you could end up with a dispute with your subcontractor down the road that turns into an FCA violation because you have certified to the government that your subcontractor has been paid. So paying attention to the nuanced details of your contract is very important. that could turn a simple dispute over delayed payments into an FCA suit, which could end up trebling your damages. You want to implement internal audit procedures. And what I mean by that is having someone be responsible for checking your contracts not only upon award, but during performance to ensure that you are performing in accordance with the obligations of the contract. You also want to have standard operating procedures. How, when you win a new contract or you begin performing on a subcontract, how are you following those, or how are you ensuring that you're meeting those obligations? You should have operating procedures in place that describe who is going to be reading the contract, who's responsible for determining compliance issues, and who does the due diligence to ensure that the performance is in compliance to avoid FCA liability. We recommend that you specifically assign these duties to an employee, usually a high-level employee in your contracts department, and you maintain internal checklists to ensure that you are documenting that you are in compliance and that you have been checking throughout. You'll also want to implement training. And what I always say is train your trainers. So you may have individuals who are very well versed in contracts, but you want to make sure that they know what they need to be training the teams on. So someone who's very familiar with the contract, you may have a legal representative who can help train the individual who is training the workforce. And you want to go back and check several times during performance to ensure that all contract compliance issues are resolved on an ongoing basis. We've said this a couple times. You want to take employee complaints seriously. There was a cybersecurity fraud FCA claim that was settled a couple of years ago for about between, I think, 8 and 10 million, where an employee reported to his supervisors on several occasions that he felt that the program was not in compliance with federal obligations for cybersecurity requirements. The company dismissed the complaints repeatedly and informed the employee that they were resolved and should not be considered or brought up again. Later on, the employee was demoted and then let go because they were a problem employee. That employee filed a qui tam suit, became a whistleblower, and ultimately it settled for between $8 and $10 million later on. The employee got approximately $2.5 million for his report. All of that could have been resolved if the company had listened and investigated the individual's complaints at the time they were made. When we talk about investigating complaints, we mean actually investigating it. It's one thing to check the box and say we've investigated. It's another to actually talk to people, pull the documents, go into your system and ensure compliance, and to make sure that everybody is on the same page. You want to document that investigation. Make sure there's a paper trail. You want to make sure that you've written down what you did to ensure compliance. You want to make sure that you're keeping that documentation available for years so that you can provide it to the government if there's a question or your lawyer. And you also want to implement a contingency plan. What happens when a complaint comes in, whether it's from the FBI, the Department of Justice, the Office of Inspector General, or an individual complainant, someone who's an employee or a competitor who writes you a letter and says you're not in compliance for XYZ reason. You need to have a contingency plan. How are you going to respond when that complaint comes in? So what do you do when you discover a past or current FCA violation? One that you believe in good faith is occurring and you need to solve the problem. First, obviously you want to correct the problem right away. FCA damages compound over and over and over again. Every time you submit an invoice that is false, that False Claims Act damages just increased. You also have a mandatory disclosure requirement. So if there is an FCA violation that you have discovered, this happens not infrequently when there's a merger or acquisition and you, as you're transitioning to take over the acquisition target's contracts, you discover that there are mistakes either in the disclosures to the government or in performance. You have an obligation to notify the government. It's called mandatory disclosure. When you disclose, you may still have liability to the government, but the government is going to take it slightly easier on you and they are often going to work with you to ensure that the performance is corrected in a way that is best for the government and limits your liability. But making these mandatory disclosures and cooperating in the government investigation into this type of situation can earn you what's called cooperation credits. It can reduce the amount of liability that you ultimately would be found to be responsible for in the event of an actual FCA violation. So what happens if you're faced with an FCA matter? And what I mean by that is you've received a subpoena, a civil investigative demand, or you've been served with a lawsuit. If the United States is initiating the matter, a government initiated matter, you're probably going to get a subpoena or civil investigative demand on the front end. You'll know that there's an investigation, and the government will tell you in advance that they're going to file a lawsuit. If there's a whistleblower involved, the process is a little bit different. The whistleblower files a complaint under seal in federal court. The defendant is not notified of the suit, but the relator, key tam whistleblower is called a relator in the industry. They file a memorandum with the court and serve it on the, or I should say, they serve it on the Department of Justice, and the Department of Justice then investigates from that point forward. They may serve a subpoena, like a grand jury subpoena, or a civil investigative demand, much like if a government initiates the matter itself. But that investigation will take place over the course of many months or years. The government will ultimately decide whether to intervene, and when the government just makes that determination, the case will be unsealed and a copy of the complaint will be provided to the defendant. If the defendant, or I'm sorry, if the government declines to intervene, the relator or the whistleblower will proceed with the lawsuit on their own. If the government intervenes, then the government will proceed and take over the control of the case. But assuming all of that happens, you could get notice through a grand jury subpoena. That usually is where the government has received credible allegations of a criminal violation of the FCA, typically a willful violation or one with actual knowledge. Doesn't mean they're going to be able to prove it, but they've proceeded to make a preliminary determination that they're going to take it to the grand jury. That doesn't always happen. Just because you've received a grand jury subpoena does not mean that there's going to be criminal liability or even a criminal charge. It just means that it's being considered for that. You also could receive a civil investigative demand. That typically means, and it'll come from either the Department of Justice or the Office of Inspector General. For an agency, those typically mean that there is only a civil investigation. They are very similar documents, though. They are requests for documentation or information. They might be written questions called interrogatories, or they might be a request for an interview, a recorded interview like a deposition. You could also receive a civil subpoena if you are not involved in an FCA matter, but you might be a witness or you might be a teaming partner. You also might receive, and this is the worst case scenario, the FBI may show up on your front doorstep of your business with a search warrant. This is where that contingency plan comes in. When they knock on the door, who's the first person you call? Your lawyer, obviously. You want to make sure that you're asking to see the search warrant. You want to check to make sure it's been signed by a judge, and then you let them do their thing, assuming there's nothing wrong with the search warrant on the front, on the signature page. But the main thing here is don't panic. Just because the government is investigating something doesn't mean there is liability. It does mean that you need to take the investigation seriously, and you should not be talking to the government and offering information until you've had an opportunity to talk with counsel and retain counsel to represent your interests. The worst thing that can happen is for you to sit down with the government when they have questions and answer them without thinking about your answers in advance. You may not know the nuances of the investigation, and it is natural, it's human nature to try and be as helpful as possible when the government is asking questions and accusing your business of violating the False Claims Act or committing fraud against the government. You can very respectfully say, I do not feel comfortable talking to you at the moment, but I will contact my counsel and they will work out a time for us to speak in the future. 9 times out of 10, the government is going to be okay with that and expects it, but sometimes they will respond and say, if you weren't guilty, why wouldn't you talk to me? Don't take the bait. You are not required to talk to the government up front. You are permitted to get counsel first, and you should, to best protect your interest. When you receive one of these documents, either a search warrant or a subpoena or a civil investigative demand, you need to stop all routine document and email destruction or archives immediately. It is very important that you have this documentation to produce to the government later. This is the paper trail we've been asking you throughout this webinar to preserve. If you have destroyed the documentation that proves your innocence, it's going to be harder for you to actually prove your innocence. You want to, again, obtain knowledgeable counsel to act on your behalf. The government often will take advantage of individuals who are not represented by counsel, not because they're out there to get you, but because the government already has confirmation bias. If they're investigating you, they're coming at it from the assumption that a violation has occurred. And if you give them information that bolsters their thought that a violation has occurred without vetting it through counsel, then you could be walking yourself into liability that is hard to walk back from. You want to conduct an internal investigation here, and you want to do it in your discussion with counsel. You want to try and identify knowledgeable witnesses, identify important documentation, and know where there are gaps in information where you might need to go to former employees. You want to verify your paper trail. You want to make sure that you still have it. You want to make sure that it's all in the same place. You want to make sure that it's available for your counsel when needed. And documentation, documentation, documentation. I don't just mean look for your paper trail. I mean continue to document as you go through the investigation. When you're working with counsel, those documents become privileged because you're doing it at the request of your counsel. But let's say that during the course of an FCA investigation, you happen to hear at a company party or happy hour that someone knows about the investigation that you didn't disclose it to. That person could be a whistleblower, and it's important to know that person's motivations to help your attorney defend the FCA violation and allegations. So ultimately, there are 3 takeaways from how to defend yourself. Be ready up front before there's a violation by keeping contract compliance front of mind. When you receive an investigation, either a subpoena or a CID, take it, or even a complaint from an employee, take it seriously. And 3, make sure you are documenting your business all along the way, preserving your corporate records, and ensuring at the end that when you have an attorney who can help you, that they have all of the information and historical information necessary to help defend you from the potential significant liability of the FCA. We are finishing a record 2 minutes early for this webinar. So if you have any questions, please shoot them up onto us, onto the board now so we can answer them. Otherwise, if you have direct questions for me or Annie afterwards, you can certainly reach out to us. Our contact information, phone, and email is on the webinar slide that is up. It has, as always, been a pleasure talking about the FCA with you. If you'd like to talk about it, feel free to reach out to us. We appreciate your time and thank you very much. No questions are coming in, so we'll let you free a couple minutes early. Thank you all and have a great rest of the week.